Hello, Geoffrey Nice is my name, and welcome to this, the first of this academic year's 4 lectures or debates in the context of law series that's been running for several years now. For those of you who haven't been before, the format we use is quite important. The 2 speakers will have 2 sessions of 10 minutes each, so it's sort of A, B, A, B. It starts off the process of discussion, and they'll each have about 10 minutes for each of those sessions, 40 minutes. That leaves at least 15 or 20 minutes for questions and answers. And here, I'm afraid, you're going to be subject to some fairly tough rules. The first is that if you ask a question or make a point, please don't thank the speakers. It wastes time. We'll do that at the end. Please don't identify yourself unless it's critical to what you're saying. And please reduce by previous editing in your head your point or question to 30 seconds. That way, more of you will be able to speak. We have a much swifter flow of ideas, and you'll find that the overall 15, 20 minutes of question and answer serves a great purpose. If you want an analogy, think of yourself as, what is it, the Sarah Montague or the John Humphreys of the Today programme, not the late, great Lionel Blue doing his 3 minutes on Thought for the Day. 30 seconds. Now, tonight's issue is one of enormous seriousness and sensitivity that may affect any of us, for ourselves, for our family, or for our friends. And we are fortunate indeed in drawing on the resources of the Inn by our 2 speakers. Lord Falconer, former Lord Chancellor, as you will all know, who will go first, introduced a bill about assisted dying, which was timed out in the House of Lords to be followed by a similar or identical bill in the Commons that was eventually very substantially defeated. Baroness Butler-Sloss has spoken against the principles or the arguments that Lord Falconer has advanced and others have advanced, both in the House of Lords and elsewhere. And so we have 2 speakers who can guide us in our thinking and lead you into the discussion that you will have later. Lord Falconer first, please.
Geoffrey, thank you very, very much indeed, and thank you to the Inner Temple for having these lectures, and thank you as well for inviting me to speak in relation to them. I think the assisted dying issue raises huge moral and ethical issues, but also raises tremendous practical issues as well. I think one should look at it in as objective a manner as possible. Can I start with the particular? Gloria Taylor, in 2009, was diagnosed with a fatal neurodegenerative disease which is called amyotrophic lateral sclerosis, ALS. What ALS does to you is you first lose the ability to use your hands and feet, then the ability to walk, chew, swallow, speak, and eventually breathe, and then you die. It is very difficult to tell how long this will take. She made an application to court in order to be allowed to have a physician help her to take her own life. Her evidence, summarized, was this: I know that I am dying, but I am far from depressed. I have some downtime. That is part and parcel of the experience of knowing that you are terminal. But there is still a lot of good in my life. There are still things like special times with my granddaughter and family that bring me extreme joy. I will not waste any of my remaining time being depressed. I intend to get every bit of happiness I can wring from what is left of my life, so long as it remains a life of quality. But I do not want to live a life without quality. There will come a point when I will know that enough is enough. I cannot say precisely when that time will be. It is not a question of when I can't walk or when I can't talk. There is no preset trigger moment. I just know that globally there will be some point in time when I'll be able to say, this is it. This is the point where life is just not worthwhile. When that time comes, I want to be able to call my family together, tell them of my decision, say a dignified goodbye, and obtain final closure for me and for them. My present quality of life is impaired by the fact that I'm unable to say for certain that I will have the right to ask for physician-assisted dying when that enough is enough moment arrives. I live in apprehension that my death will be slow, difficult, unpleasant, painful, undignified, and inconsistent with the values and principles I have tried to live by. What I fear is a death that negates as opposed to concludes my life. I do not want to die slowly, piece by piece. I do not want to waste away unconscious in a hospital bed. I do not want to die racked with pain. So she asked the court to make it possible for her, when she had less than 6 months to live, as diagnosed by a doctor, to be assisted to take her own life. She plainly, although she has the right to take her own life if she can do it herself, she plainly couldn't do it in that state. If she was going to take her own life, then she would have to do it much, much earlier than she otherwise would want to. She could go to Switzerland, but she didn't have the financial resources to go to Switzerland and die in the Dignitas clinic in Switzerland. The English courts say absolutely not to that. There is a law that says anybody who assists somebody to commit suicide is guilty of a criminal offence, which, if you're found guilty of it, can attract a maximum penalty of 14 years. The British establishment find that unpalatable, because when you hear Gloria Taylor's case, you think, God, if somebody helps you, if somebody helps Gloria to kill herself for the best motives, we don't want that. That's just, it's too much to swallow for a system to say that that is a criminal offence that can lead to 14 years in prison. So the way that we deal with that is we say that the Director of Public Prosecutions, a most genial and well-intentioned public servant, will consider the material as to whether or not the motivation of the person who helped the deceased to die was good. Namely, it wasn't in order to make money, it was in order to assist somebody in extremis at the end. If their motivation was good, then the Director of Public Prosecutions will decide not to prosecute that person. Of course, if the Director of Public Prosecutions takes a different view and a prosecution is brought, then there will be no defence for that person, because a defence of good motivation is not a defence to the crime of assisting somebody to commit suicide. One other point. The DPP has made it clear that he will not allow doctors to assist with suicide. So the current law in England, when confronted with Gloria Taylor's case, is to say, you can't get a doctor to help you. You can go to Switzerland. If your relatives help you, as long as they're amateurs, it's okay. That is a law that offends against the most basic principles of English law, namely that your guilt and innocence should be decided by an official, even a well-meaning official. It is so cruel. Why should Gloria Taylor go through this? 3 answers are given. First of all, well, if you let people have the right to take their own life, assisted by a doctor, you might end up in a circumstance where people are over-persuaded by their relatives to take their own life when really they don't want to die at all. Correct, there needs to be safeguards. 2 doctors and a High Court judge saying it was okay was the safeguard in my bill, which I think is a pretty high threshold. Take a comparison with those who are terminally ill, who are dependent on life support of some sort. They are entitled, as a matter of right, without any regulation at all, to have the life support removed. They're just as vulnerable to being over-persuaded by their relatives. Nobody suggests for one moment that there should be any protection in relation to them. The second objection is that how can you tell whether somebody's got 6 months or less to live? Absolutely. It is difficult to judge precisely how long somebody has got to live, particularly if you're 6 months out. But these decisions about whether people are terminally ill are decisions that doctors face the whole time in determining, for example, whether they start to give end-of-life treatment. This issue about end of life, whether it be being given the right to an assisted suicide or whether it's the right to have care taken away, always arises in a medical situation. Of course, it's an imperfect science, medicine, particularly predicting how long you've got to live, but I don't think that is a reason why you shouldn't have the right, if you want to, subject to a doctor saying it, to take the risk in relation to what a doctor says. And then the third objection that is given is, well, people might get very depressed and vulnerable at the point that they are dying. They might well, even though people are depressed and vulnerable, people do often want to take the option of an assisted death. And in my view, people's autonomy, which is absolutely key to my argument, should be respected in this of all occasions. I feel for myself that if I were dying and had less than 6 months to live and all interest in life had gone and I was simply a burden to my children, who are adults now, then I think I probably would want an assisted death. And I don't think it's wrong to think part of my motivation is I don't want to be a burden to my children. As Gloria Taylor said, she didn't want her life in the eyes of her children to be defined by the last few weeks or the last few months. Just being there and holding on for no other purpose than to get to the next day is not a life that very many people want. Marvellous things can be done in palliative care. I'm not saying this should be compulsory, but it should be, as a result of people's right to decide how they die, a right subject to safeguards that everybody should have. So I am strongly in favour of an assisted dying bill. We are a country increasingly being left behind in relation to this. It is time for a change. The current spatchcock arrangements are so unfair and so cruel. It is definitely time for a change. Thank you very much indeed.
May I first apologise because I've got a cough. The trouble with having a cough is it can't be controlled, or not very easily. Charlie Falconer, Master Falconer, has done an extremely good, as I would expect, expose of why this should happen. I should start by saying that I am a vice patron of the Exeter Hospice Care, and so somewhat involved in palliative care. There are moral and ethical, there are religious reasons, both for and against assisted dying. And I think one needs to know what assisted dying really means. It means helping somebody to commit suicide. And also it is a question about how far that person assisting should go with someone who is unable or almost unable to help themselves. Autonomy is what Master Falconer said. My view is there is a limit to autonomy to protect the most vulnerable people. There are a very large number of very vulnerable people living in care homes or living at home in not very good circumstances. And if they are in care homes, or if they have a lot of help at home for which either they or someone else is paying, the money, which is usually not very much, is going on that rather than going to the next generation. And Master Falconer dismissed that. But I knew an old lady in a care home being supported there by members of a family. And she used to say to me, I really ought to die. I shouldn't be costing them all this money. She wasn't terribly bright. She was very conscientious. And she is exactly the sort of person who would be very easily persuaded into thinking she ought to die. And if she took that view, and if the family had, by rather clever suggestions, put that into her or had agreed with her, having 2 doctors and a judge would probably not change her mind. So I am very concerned about vulnerable adults in old age with the money disappearing as it does far too soon. The next question really is, how do you do it? And there are very major problems because Master Falconer has not said to you what is the position of the medical profession, but all the medical colleges are against it. The majority of doctors are against it. They are trained to save life and not to take it. Consequently, there are doctors out there who would do it, and I think one would end up with this sort of group: the doctors who'll do it on a list, and the very large number of doctors who won't. And there is a very real problem. The doctors who say they'll do it will do it with possibly increasing enthusiasm. There's a real difficulty in depression. Again, Master Falconer talks about why shouldn't somebody who's depressed and indeed vulnerable take their own lives, or if they can't do it because they have motor neurone disease, as an example, why shouldn't someone else help them to do it? The trouble is that for many, many doctors, it's extremely difficult to identify whether somebody is just depressed and therefore has the capacity to make decisions, or is clinically depressed. One of my very close friends told me that when she got clinically depressed, she went down in a pit with smooth sides, and it took her a very long way to clamber back out of it. And she told me that she realized that when she was in the pit, she really didn't have the ability to make decisions. And consequently, if you have 2 doctors, one of whom I think is being suggested would be a psychiatrist or a psychologist, not a doctor, then they would have to have the ability and indeed the preparedness to identify exactly why it is the person wants to die and whether they have the capacity to do it. Now, one of the questions is, why do you draw a distinction between those who are kept alive artificially and those who want to die but can continue to eat and drink normally? The major ways of being kept alive artificially, as I'm sure you all know, is either by ventilation or by a peg in the stomach through which food and water is provided. And my nephew Philip's here, and he appeared before me in a famous case called Miss B, in which Miss B undoubtedly had capacity to make the decision that she wanted her ventilator turned off, and the doctors were so fond of her they couldn't bring themselves to do it. And so there was, in fact, a case before me. Did she have the capacity to say, I want to turn it off? And I took the view she had the capacity and she chose to die. But if you are actually asking a doctor to help you to kill yourself, the question really is, how far are you expecting the doctor to go? And in, I think, the latest bill that Master Falconer brought to the House of Lords, the word was used in jest. And one of the difficulties is the doctor actually to put the pills into the mouth of the patient? Or is he to try and have it so that she or he can do it? And one of the other problems, as indeed the Master Falconer has pointed out, is the last 6 months. And if we are to have any sort of law that says you can only have the help of doctors to kill yourself in the last 6 months of life, there will be a very large number of people out there, not very large, but of those who want to die, who would consider this to be extremely unfair. And it is very difficult to tell the last 6 months, but assuming that is the situation, interestingly, those who've been to Switzerland with Dignitas, I don't believe any of them were in the last 6 months of life. They chose to go before the last moment. So they would not be that group of people who would, in fact, be helped. And therefore you would have two sorts of people: those who were being allowed to die in the last 6 months by their own hand or with the very considerable help of 2 doctors, the one who would have to be present when the pills were administered, and those who felt that this was very unjust. And I have absolutely no doubt that if we have a law that allows you to do it in the last 6 months, there would be overwhelming pressure for this to be extended. And then you bring the old lady I told you about and other people like that. And my view is there have to be limits to autonomy for the protection of the genuinely vulnerable. Palliative care is good in this country. Interestingly, it's much better than it is in other countries like Holland, and I've discussed this with Dutch people. They don't really need palliative care because it's very easy to die, and indeed not only do they have assisted dying, they also have euthanasia. And consequently, if somebody wanted palliative care in Holland, it would be very difficult. Now, around the country, on the whole, it is very well done, and people are working to make it even better. Consequently, I would say be very cautious. Just look at this again. Look at the fact that the government is against it. Parliament is against it. The majority of the medical profession is against it. And say, why is that? And be very, very cautious.
Master Butler-Sloss didn't really address the main argument as to whether or not Gloria Taylor should have the right to take her own life. It was all the dangers. She talked about people, quote, committing suicide, which is the language of 1961. In the context now of issues about mental health, the language of committing suicide is a crime. And I think we have a different view about those things now. Her central argument was that there are limits to autonomy. I agree that there are limits to autonomy. I think by and large, the state should not help people to take their own life if they are not dying in any event. And that's where I put the first layer of the limit on autonomy. We should not be helping people who are depressed at 45, or even people who have a disability that is not going to shorten their lives. We shouldn't be helping them to take their own life. But we should be willing to think about how people end their lives when they're dying anyway. So that's the first place that I put the limit on autonomy. And the second place I put the limit on autonomy is it's got to be clear that the person has got the capacity to make the decision, that it's not a decision that they have been coerced into, and they only take that decision knowing full well of what the options and alternatives are. Honestly, I think Master Butler-Sloss, when she refers to the people in the care homes who will be being over-persuaded to take their own life by their relatives who want them to stop the drain on the money, is a fear without justification or basis. Why do I say that? There have been countries that have had assisted dying for a considerable period of time. The place where it has been the longest in force is Oregon, which after a plebiscite in Oregon introduced a law about assisted dying. Prior to the plebiscite, I should say, the doctors in Oregon, probably for the reasons that Elizabeth was saying, namely that their job is to help people rather than to help them take their own life, were against it. How effective the safeguards were in Oregon was considered by the courts in Canada when a case came before the courts in Canada in which they wanted to say that the prohibition on assisted dying was unlawful under what was the equivalent of their Convention on Human Rights. Substantial evidence was called before Mrs. Justice Smith, the judge who heard it at first instance, and, quote, she reviewed the safeguards in place in each jurisdiction and considered the effectiveness of each regulatory regime. The evidence from Oregon and the Netherlands showed that a system can be designed to protect the socially vulnerable. Expert evidence established that the predicted abuse and disproportionate impact on vulnerable populations has not materialised. That was a conclusion that she reached after hearing all the evidence. I have to say myself, having been to Oregon, having spoken to the people engaged in the process in Oregon, they say it works well, that and I say this with respect to Elizabeth, the unjustified, unevidenced fears about the people in the care homes just did not materialise. And so I would ask you to reject that particular practical reason that's been given on the basis that there is no evidence. Then Elizabeth said the pressure to increase from 6 months to 12 months and God knows what would become irresistible. Again, that is given the lie to by what has happened in other countries. The way that countries start in relation to assisted dying is the way that they tend to finish. So in Belgium and the Netherlands, there is in effect euthanasia, and it can stretch down to quite young people. We don't want anything to do with that here. What we want here is the ability, when you are dying, and only when you are dying, to be assisted in relation to taking your own life. That's what happened in Oregon. It started like that in Oregon. There has been no further pressure. That's what it's been like in all the other American states. That's what it's like in Canada. That's what it's like in Victoria. There isn't pressure to go beyond that. So I think that is wrong. In relation to the position of the doctors, I completely understand what Elizabeth is saying in relation to that. But once the scheme is introduced, and again, this was my experience in Oregon, the doctors thought it was a good thing. And the reason the doctors thought it was a good thing is because it in respect of a significant number, but quite a small number, the comfort of knowing that they've got that option if they want it. Exactly what Gloria Taylor said in the evidence she gave to the court meant they lived for much longer. I thought Elizabeth's point about the fact that people go to Dignitas often long before they've got 6 months or less to live is absolutely right. But isn't that because if you want to be sure you can die on your own terms, you've got to do it at a time when you can travel? Honestly, one's got to go through each one of these practical points and see whether or not they're sufficient, either on their own or cumulatively, to say we shouldn't have this right at all. And honestly, I don't think they even begin to make a case to say that you shouldn't have this right as long as there are appropriate safeguards. And the evidence from all these other jurisdictions is that those safeguards work and the right should be allowed. Thank you.
Well, I'm sorry not to have spoken about the lady, the woman Gloria, but it seemed to me, hearing her story, this was a strong emotional plea, and I didn't feel that there was much that I could say about it, because it is true of a certain number of people that they do want the right to bring their lives to an end. But a great many other people don't want that right, and there are those who fear the consequences. And whatever Master Falconer may say, I think the 6 months produces a very odd situation for those who are, in fact, dying, but may die over a number of years. And motor neurone disease is one of the most obvious. And to be told, yes, well, you can die, be allowed to be helped to die in 2 years' time, but not now, when other people she can see perhaps are being able to. I don't resile from the fear of pressure. I've come across it in my judicial life in all sorts of ways, and although it may not have evidence of it that came before the court in Canada, it undoubtedly exists, particularly where money is concerned. Another area that I am concerned about is not only the doctors having the ability to decide whether or not there is capacity to make that decision that they want, the person wants to die. And in the Miss B case, we ended up with 3 doctors having to look at that. But in other countries, they allow, thank you very much, they allow those to die who do not have capacity. And that I would be extremely worried about. Dementia is one example. And I think I'm right in Holland. They can, in fact, allow people to die with dementia. But those are the sort of problems that I see. There is a moral part to this, but that is something which is so personal to people. I don't feel that I am justified in saying to you that my moral view that this is wrong should be your moral view, because it's not Charlie's. And consequently, that's why I didn't deal with it. But I think the way forward in this country is to look to see what the majority of our doctors feel, particularly the College of Psychiatrists, who are extremely concerned about it. And again, I have to declare an interest. I'm an honorary fellow of the College of Psychiatrists, and they haven't actually spoken to me, but they have produced a paper on this, which shows the concern that they have. And I think the way forward is to spend more money and to have greater help in palliative care, and to see that people should die with dignity and with as much help as they could have. And I'm interested that there have now been the suggestions that the doctors are not being properly trained about talking about death. And one hopes that at the student level of medical students, that is an issue that they should grasp, because we all ought to be able to talk about death. But we do find it very difficult, I know, or many people find it very difficult. So I have to say, resile from a single word I said. I'm not going to repeat it. You're all intelligent people. It'd be a waste of your time to do it. But I just say to you, no.
Just before we go to questions, one point that arose from what Elizabeth said, which was the moral issue. Obviously, I don't have a moral objection to it. Indeed, I think it is cruel and therefore immoral not to allow it to happen. the significance of the moral issue, I think, in adjudicating on what you're hearing is what is the moral position of those opposed. So I'm not asking Elizabeth to say what her moral position is, but very many people who are opposed to assisted dying are opposed to assisted dying, in fact, for moral reasons. So that what you will find is, for example, the Catholic Church is opposed to it, the Anglican Church is opposed to it. They advance practical reasons, but in fact, beneath the reason for their objection is a moral reason. They think it is immoral, and I don't disrespect them for this, but they think it's immoral to allow people to be assisted to take their own life. The significance of that, I say, is this: that should make the audience, when listening to somebody who in fact has a moral objection to people being allowed to take their own life, that will no doubt colour the view they take of the practical arguments. I don't know what Elizabeth's moral position is.
Isn't this typical of Charlie? He gets a third go. I would just add to that, if I may say, whatever may be the moral view, if the practical points that are made are good ones, whichever is the basis of it seems to me completely irrelevant.
Can you all hear, by the way, with this microphone? Good. To me, each side has several difficulties. On the one side, should people be obliged to be kept alive for dreadful deaths that include pain as well as loss of all function? On the other hand, is it possible to argue with any confidence that there are no cases where pressure will be brought to bear on people arising out of the financial considerations that Elizabeth has been raised? Those are some of the thoughts that I've had, but now, by the way, those of you who arrived late, not late, but didn't arrive early, there's a rule, and that is that you can ask questions, but they only last 30 seconds. So we'll come to you later so that you can pick up the drill from those who here earlier. Who would like to start? There is a microphone, and here it comes. Charles.
I will say who I am. I used to sit at the Old Bailey. Since then, I have joined a chaplaincy team covering the hospices in Northamptonshire. And I assure you that my views are based on morality. They have to do with the relief of suffering and the helping people who are dying to achieve peace of mind. So make no mistake about that. Time and again, working with people who are dying, we have found that they move through phases of wanting to die, wanting someone to help them to die, and they move through it with decent palliative care, with proper chaplaincy intervention, which isn't necessarily religious at all. Had they committed suicide at a particular point, their lives would not have achieved the fulfillment that I've frequently seen patients achieve, and more importantly, their families. There is often complete mutual misunderstanding between patients and their families. The patient thinks, I'm a terrible burden. I'm a burden to my family. I want to die for their sake. The family think, he's suffering so much. We can't bear to see him like this, so we support him dying. In fact, neither of them really wants it.
Charles, you've broken the 30-second limit.
Right.
So I'll ask you a question. What about those who genuinely want to die but are restrained by circumstances over which they have no control?
That's a perfectly fair point. That's a point which goes into the balance. It's a good point, and it goes into the balance. I've got one other thing to say. I know I've gone over. Pressure doesn't just come from, potentially from families. It comes from doctors. Read Catherine Mannix's book. Read about the Dutchman who discharged himself from hospital in Holland, because killing him was a treatment option, it had to be discussed at every stage in order to, for him to give informed consent. Every time he saw a doctor, the possibility of the doctor killing him was mentioned. He felt under huge pressure.
Could I just make one point about this, which I failed to do, just picking up what you're saying, which is that another group who are wholly opposed to this are those who are disabled. And we have a number of people in the House of Lords who are very disabled, including one who comes in with a, what do you call it, a mask, oxygen mask most of the time. But she was very anxious about Charlie's bill and said, you know, we will be in danger, she took the view, if in fact this becomes law.
First of all, Charles's point. Charles is right in what he describes about some people. My experience of talking to people who are dying is, for many people, similar to what Charles says. I have absolutely no doubt, though, that there are a great number of people who I meet who are dying who are absolutely determined that they do not want an undignified death. It's a small number, but it is unquestionably a number. And I do not believe, Charles, that if you are purporting to say everybody comes through the process, that you are right. I am absolutely sure that you are. You didn't say that. Exactly right. You didn't say that. So those people who come through it and should be helped come through it, that is absolutely right. Secondly, Elizabeth's point about the disabled. There are organised groups of disabled who are against the bill, including Baroness Campbell, who is a incredibly admirable, very disabled member of the House of Lords, who has spoken very effectively against it in the House of Lords. Polling has been done over approximately 10 years about what is the level of popular support for assisted dying, and it's always hovered between 75 and 80%. Those who are disabled are at exactly the same levels as the able-bodied in these polls.
I'm not sure that your figures are right, but I can't at the moment look them up. But I would just raise a question mark as to the polling. I'd also ask the question, I wonder how the question was framed.
Yes. Microphone coming your way.
I say Henrietta is going to get a lot of exercise.
This is a question for Lord Falconer. I understood from your argument that the key point was to avoid people living in cruelty because of the quality of their life. So take the Gloria Taylor example. The point was that at some point her quality of life dips below a tolerable level. So if that's the case, I wondered why introduce the 6-month limitation. Is that an expediency point, or is that something more principled?
For me, the key point, and I obviously didn't explain this well enough, was autonomy. If you are dying, you should be entitled to make your own choice about how and when you die. And for very many people, as in Gloria Taylor's case, it will be about the quality of your life. But the key thing is autonomy in relation to it, which is what our freedom is about, in a way. I don't believe it should be extended to people who, for example, have got disabilities or illnesses that make their lives, by their own standards, intolerable, because I can see it's wrong for the state to encourage people who are otherwise got a life expectancy to take their own lives. But if you are dying, then I think autonomy demands that you be able to decide when and where you die. And for many people, they will die before it becomes intolerable. And for many people, the intolerableness is not the pain. Pain can often be dealt with by palliative care. For many people, the intolerableness is the lack of dignity and the dependence. And if that's what they want to avoid, then they should be able to do that.
The question, I think, included why 6 months. I think it's thought it's more likely to get through Parliament.
And I would add as a supplement before we take the next question, what about those who know they are going to have 9 months, 1 year, 18 months of a miserable decline into death? But let's take a question. Yes, ma'am.
This is, excuse me, I also have a cough. This is also for Lord
Could
Falconer.
you come round, because I can't see you and I'm slightly deaf. It's okay. Well, if you're hidden, I couldn't hear it.
You've spoken about the death of the body, but what about the death of the self? What about cases where a person has Alzheimer's, for example, and they are diagnosed and they face years of decline, at the end of which they will cease to have autonomy? So can a person prospectively decide at a certain point they want to be, at that stage, assisted in dying, when at that stage of their lives they will no longer have the autonomy?
My answer to that is, I'm afraid, no. The key principle is autonomy, and that involves the person making the decision at the time they are assisted to take their own life with full capacity. How you are when you have lost capacity may be very different to how you were when you thought that's what you would have wanted in a year or two's time. So I am very profoundly against that, and I'm very, very profoundly against the idea of there being any form of euthanasia, which is what it would probably amount to, with somebody with Alzheimer's. You cannot do that in the world in which we live. So I'm afraid no is the answer to your proposal, if it be a proposal.
Let's rephrase the question.
One moment when we agree. There is a major problem if you allowed it for people with Alzheimer's, people with dementia, people who had very low cognitive ability. We would end up, wouldn't we, not only with euthanasia, but probably with eugenics, which we had in certain countries in the 1930s. And that would turn us from a tolerant country with high moral standards into something completely different.
I think there's a contribution from the door at the back, if Henrietta could help us.
Hello. First of all, I'm a tetraplegic at the back, so I speak as somewhat of an authority on the disabled community. The point I was making was, according to statistics on those who are spinally injured, if you ask someone who's spinally injured after 6 months whether they would like to continue living, post-injury, you're talking in the sort of 80% range. You say, actually, I'd rather die than live like this. Once you've spoken to someone after 5 to 10 years, the number drops dramatically, and this kind of leads into an earlier question about a phase you go through depressive cycles and things like that. There was a case a number of years ago, and you forgive me, I've forgotten, there was a paraplegic, Daniel, someone, and he was actually taken to Dignitas after only a year of a spinal injury, where he was allowed to end his life. So my concern is, if you're going to make the system easier, more people are going to take advantage of this system and end their life prematurely. And also, given the fact there is an enormous mental health crisis in this country at the moment, and the biggest killer of people under 40 at the moment is people taking their own lives, do you not feel that this is opening the floodgate to wider social problems where people will find excuses to end their lives, given the fact there's a lot of social pressure at the moment, given mental health crisis? Thank you.
I think this is for you to begin.
No, I don't think that. You're absolutely right in what. Can I stand up so I can? You're absolutely right about the young man from Wales who was taken by his parents to Dignitas after an injury at playing rugby had left him a quadriplegic, I think. And the experience that you describe of people being in despair and then coming through it doesn't apply to everybody, and it would certainly, I don't know what would have happened to Daniel, but if the law that I am proposing came into force, first of all, Daniel wouldn't be included within it because Daniel's life expectancy was not reduced. Secondly, the effect of my law would be, I think, to reduce to nil the people who are willing to go to Dignitas, and what's more, because it provided a identified circumstance in which the prohibition in Section 2 of the Suicide Act was entitled to be broken, it would mean that if you weren't in those circumstances, you would be much more likely to be prosecuted. So far from leading to it making more likely there'll be more Daniels, I think the effect is there would be less Daniels.
I think that you're right in raising these concerns. And I don't think it would stop people going to Dignitas, because I don't believe most of them are within that last 6 months. And that's the problem. These are people who've wanted to die earlier, and I don't think that that will have any effect on it. And I am very concerned about the 6 months, because I cannot believe that once you've got 6 months, you don't have such pressure to increase it, that at some stage it would be increased.
But I'm making a different point. I'm saying if you have a situation where you've specified in legislation the exception to the ban on assisting somebody to commit suicide, then you won't any longer have this fudge with the DPP. If you don't have the fudge with the DPP, then taking somebody to Dignitas, like Daniel's parents did, would be a crime. What happened to Daniel's parents after they went to, and it's an absolutely heartbreaking story, after they took him there, they came back, they were then investigated by the CPS. It's an absolutely horrible story, just after they'd lost their son. But the truth would be they wouldn't have been able to do it in the new world, because there would be this exception and they wouldn't be in it. And
that wasn't in your law.
It wasn't in my law, no. But my law provided an exception to Section 2. Why would the DPP, once Parliament had said this is the only exception, then be able to suspend the law in another area? And the difficulty in the law is poor Daniel's parents can't say no because of the DPP's, the squidgy law with the DPP. If you want circumstances in which you can do it, you should be clear about it and you should put it in legislation, and then you don't end up with the situation that the questioner was asking about.
Probably not.
This is for Master Butler. Earlier on you mentioned that medical professionals are uncomfortable with explaining deaths to patients, or are uncomfortable with the rules surrounding assisted dying. In the past, there have been many rules that have been enforced. They have been uncomfortable with them, but they've grown within the years. Why can't this be an exception? So why can't they be comfortable with what's been introduced?
Well, I don't know of the past where, in fact, doctors have assisted someone actually to die as opposed to not preventing it. And what's happening with the medical profession at the moment, the majority, not all the medical profession, and particularly the medical colleges, is they're opposing the fact that doctors should actually be in the room with the patient and either hand to the patient or help the patient drink the drug that is required to kill them. And I don't know of anything in the past where that has happened.
Maybe the question I had other circumstances in mind, for example, abortion, maybe? Yes. The question, I think, is if Parliament has if Parliament representing the people changes the ground rules, should not the doctors ultimately be prepared to fall in line? And do they not do so, as, for example, in abortion?
Well, abortion has a number of doctors who refuse to do it. But you're quite right, the majority of doctors do. As it happens, unless you're a Roman Catholic, the fetus is not treated as being alive, as being a human. Therefore, if the fetus is terminated, that can't be an offence, because English law does not accept a fetus has any rights. And there have been, the European Court of Human Rights refused to interfere with it, and the cases in this country have accepted that that is the law. And consequently, although I don't like abortion, I have to tell you, I can see that there is a distinction to be drawn with terminating someone who is unborn and has no rights from actually helping to put the drugs into the mouth of someone who is older and in fact wants to die.
Just, yes, I agree with the premise of your question, which is if the rules change, then you will see doctors adapt, and abortion is a very good example. I accept what Master Butler-Sloss is saying, that there will be some people who have a conscientious objection to performing abortion, and of course they shouldn't be forced to, and it's similar in the bill that I proposed. The other piece of evidence that is relevant to your question is Oregon, where the doctors were against it before the law changed. Once the law changed, both, as it were, the generality of the doctors, and in particular doctors engaged in hospice care, would now tell you that it's a good thing because it gives people an option and it helps people face the last few months of their life, very often in circumstances where they know they've got the safety net of the ability to take their own life, and very many people then don't use it.
We'll turn to the next question, but can you answer the question I raised at the beginning?
Yeah.
Do you accept that under your bill there would be people who would be subject to financial pressure, and if so, to do what they otherwise would not do? And if so, are you making a balanced judgment that this is better than the alternative?
Looking at the evidence from particularly Oregon, there is no evidence of any case where this has happened. I do not think that a two-doctor and High Court judge safeguard is going to let very many cases, if any, get through the net. We are not talking here about very many people who want to do this. Maybe 1,500 in a year, if the same sorts of percentages that take up this option as take it up in Oregon. And I think 1,500 is the courts can be will be successful.
Okay.
Thank you. This is mainly for Master Butler-Sloss. Can most of your issues not be properly countered with safeguards? Because, for example, there are exceptions in other areas of the law where if people don't want to do something, they don't have to do it, mainly in equality cases, in circumstances of that nature. Could doctors not just object to do it if they didn't want to do it? And if they didn't want to do it, then it wouldn't be a problem. Centrally, the issue is autonomy. And equally, your point you quite rightly made about, well, what if people don't want to do it? If they don't want to do it, they don't make the application. It's better that people that want to do it and will need to do it if they want to have the opportunity than a complete prohibition on everyone. Surely.
I'm waiting for you to sit down.
Oh.
I think the point really is this, that in this country, the majority of the medical profession is against it. So you would end up with a small list of doctors prepared to do it. And then I think the problem would be, they wouldn't be the doctors who knew the patient. And I think there are problems, including the problem of identifying the capacity of a patient as somebody whom they didn't know. But yes, I'm sorry about this. I see the point you're making. I don't agree with you.
On the basis of opinion polling, the vast majority of the public are in favour of this. Elizabeth, I use this word advisedly, slightly sneers at opinion polling, but swears blind.
No, I didn't sneer. I said, I'm not sure your figures are right.
Yeah, sorry. You sneered at me, sorry. No, but I think most people would agree with the proposition that the polling is strongly in favour of it. A significant number of the medical colleges are against it. The extent to which doctors are as against it as Master Butler-Sloss is saying is, I'm not sure. I find when I talk to doctors, there are three categories of doctors: those who are vehemently opposed to it, those who are vehemently in favour of it, and quite a lot of doctors are vehemently in favour of it, and the vast, vast majority of doctors who you talk to who say, I don't know what the law is at the moment, for God's sake make the law clear. All I want to know is what's allowed and what's not. And I suspect that although, yes, there are significant numbers of doctors who are against it, it's not this massive number that Master Butler-Sloss is saying.
We don't all go gentle into that dark night. I've spoken to many doctors and nurses who say that death is very, very difficult at times. Surely we ought to be able to mitigate that when someone is in terrible pain. I have seen a member of my own family sent to not one, not two, but 3 hospices, because each time he was still alive. You're only allowed to stay there 2 or 3 weeks, apparently. I rest my case.
Could I just
Yes, of course. Yes.
Could I just say something about that? The hospice of which I am, I think a vice president actually, not a vice patron, takes people in for a week or two for respite care, and then cares for them in their own home. And the service offered down in Exeter and this part of Devon is extremely good. And the people nearly all stay at home, and a very small number actually die in the hospice. They nearly always die at home with the care of the various people who do it. And they have a number of respite places that they can go to for the day, or they can stay for a few weeks or a few days.
Okay, so my question is for Lord Falconer.
Louder, please.
My question is to Lord Falconer, and it's kind of linked in with the question that my colleague asked in terms of if doctors don't want to do it, why don't they just not do it? I think there are so many policy issues that come in. So if you work for a trust or something like that, and the trust agrees to do it, you have to do it, or else you might end up losing your job as a doctor in that trust or even in that field. So morally, some doctors might want not to do it, but they might be coerced, or they have to do it because of policy issues in the trust that they work in. And also, I wanted to find out, in terms of the law that you're looking at implementing, if it comes in between with some clarification in terms of whether it's going to be allowed, will the doctors have the options not to do it if they don't want to do it, because then their conscience is clear, or they want to do it because they want to do it? So yes, even though there will be that clarity, you need that.
In the bill, sorry, thanks. In the bill that I introduced into the Lords, there was a specific clause that said if any doctor had a conscientious objection to being involved in assisted dying, then they would not be required to do it. So there would be a specific provision. The experience again in Oregon, the experience again in the other states where it's happened, is that it doesn't ultimately end up with just a very few doctors doing it. It becomes part of the suite of things that you can tell a person who is dying is available to them. And the responsible doctors in Oregon will tell the patients what's available, and if they want it, then most doctors will help the patient if that's what the patient wants. It's not something where you've got to go and find Dr. somebody in some strange part. It generally is available as a normal part of end-of-life care.
Well, I've no doubt that the doctors could say they wouldn't do it. I entirely agree with Charlie about that. But what worries me is, if you have this available, I think it would have an adverse impact on palliative care.
We'll take a couple more questions and then we'll have our small reception. A couple of things have occurred to me before we take the next two questions. And one is that I think some of our pets, when they are ready to die, go away, hide and starve themselves. And known to several of us in this room is somebody who was suffering from one of the terrible diseases that our speakers have spoken of. And he took the choice, I don't know what other efforts he made, of starving himself to death, with or without 6-month limit. Perhaps you'd like to think about that, and we'll take a question from over there.
Hi, excuse me. There's been mention made of drugs or a pill being prescribed. I wondered whether in the legislation that's being proposed there is a certain process, because there has been much made of pressures being put on patients by families, whether or not the certain way in which someone should die is also being something that could be pressurised and then further expanded is an issue, is something that I wanted to ask.
In the bill, it envisaged two ways of doing it. One with a drug driver in your arm or by taking the pills. It would depend upon your state of health. There were two key bits to that. First of all, it could only be done by the patient. So the patient had to either activate the syringe driver or take the pills, because we're talking here about assisted taking your own life, not being killed by somebody else. And secondly, a doctor had to be present at the time that the event occurred. The bill did not specify the particular drugs that were to be used. It was envisaged that they would be prescribed by statutory instrument by the Secretary of State for Health, because we envisaged that the position would be that drugs might change as time went on. In fact, in Oregon, you have to take a hell of a number of drugs in order for it to happen. I mean, a number of pills. And as medical knowledge increases, then you would want that to be changed. So there wasn't a specified particular pill that was used.
We're going to take two questions from over there, and I think that's going to be it.
I was curious as to what the role of the High Court judge would be in this process, because as is the case with IPP sentences, for prisoners looking for parole, the decision is with the relevant minister. And I was wondering, with all due respect to the bench, is a High Court judge suitably qualified to make this decision? If this is a matter of policy, should it not be someone from Parliament instead?
I think Parliament's the last place to do it.
We'll take the questions together. So that's High Court judge. Yes.
It's in regards for Master Falconer, in regards to the fact that in your bill you proposed it for people that have 6 months or less to live. How would someone need to prove that they have 6 months? Of course, there could be a loophole in that people may lie that they have 6 months to live in order to die.
I just wanted to ask more about this question of autonomy and how that's presented in the bill.
Right, 3 questions.
First of all, the role of the High Court judge would be, in my bill, to determine whether or not the person had capacity, and it was something that they had not been coerced or pressured into. Obviously, it would be impossible for Parliament to do that on a case-by-case basis. A High Court judge making that decision is a pretty clear safeguard that if you want to convince somebody that you can do that, you've got to convince somebody who's got the experience of making judgments about that. Secondly, 6 months or less to live, could you lie about it? You could lie about it, but in the bill, 2 doctors had to certify that in their opinion you had 6 months or less to live. Thirdly, how was autonomy reflected in my bill? Autonomy was reflected in my bill by saying if you had capacity, made the decision without pressure, 2 doctors said it was okay, and the High Court judge said it was okay, then you were free to be assisted to take your own life. You had the ability to decide once you had been diagnosed as being terminally ill with less than 6 months to live, and those safeguards had been gone through, you had the autonomy to decide when your life ended and how.
That's what his bill said.
Is there anything that either of you would like to add as a closing remark? Because it's been a broad-ranging discussion, and I think it's right that Elizabeth should have the very last word.
Yes.
Microphone.
I mean, it is. Sorry, thank you. It is an issue that brings real suffering to people, and the number of people who I have spoken to who have had a personal experience where they feel the law is a total ass is very strong. And I think the contortions the law has had to go through, the DPP, her guidelines, how they are applied, the nonsensical effect of the guidelines, indicates that the law is in the wrong place. Politicians at the moment, and I speak as a politician, are hugely disappointing in a number of ways at the moment. The public feel they're rather disappointing. Our eyes turn to the courts. The Gloria Taylor case that I referred to was a lady who went to the Canadian courts, and eventually the Supreme Court of Canada said she was right. It's utterly unfair that she did not have the right to an assisted death, and it was contrary to their Charter of Human Rights. There's a case on its way to the Mr. Conway, on its way to the Supreme Court, where two of the Supreme Court judges, Lord Kerr and Lady Baroness Hale, in an earlier case, have said they think that the current law is incompatible with the European Convention on Human Rights as part of our law. So Parliament, like so many politicians, has disappointed. Maybe the courts, like they did in Canada, will stand up and right this wrong.
I'm one of the unsatisfactory peers in Parliament.
The peers were very satisfactory because they ultimately passed the bill, not the whole of the bill. They gave it a second reading.
Oh, well, we always give everything a second reading, Charlie.
No, the Parliament had never given a second reading to an assisted dying bill before. They'd always voted it down.
Well, I'm very interested because I took it for granted we'd give it a second reading, but then you kill it in committee, which is what we did.
No. Again, an inaccurate statement of the position. There were a number of votes in committee, and each one of them was passed in favour of the bill. What killed it was not the delay, but the fact there was a general election.
Well, I'm not going to argue about House of Lords procedures. Again, I don't entirely agree with you. I think there are 2 points of view about the maximum of 1,500 people, and whether that maximum of 1,500 people who would want to bring their lives to an end this way should be allowed to change the law of this country over a very long time. And I take the view that there are such dangers about it that it would be unwise to do so.
Thank you all very much for coming. Many thanks to Henrietta and her staff for organising it. It would be quite improper for me to attempt to summarise the effect of a discussion which shows that the difficult issues on both sides remain to be resolved if and when they can. But there can be no doubt that this is a problem that may face any or all of us at some stages of our lives, and it involves confronting agonies of physical and other kinds. The first of the 4 presentations of this kind this year are, as you know, one way of making great resources in the inn available not just to other barristers and to students, but also to the members of the public. And that's one of the reasons it's being filmed, because it will be made available to the public in that way. And I think that I can probably express all your views in saying that this has been a most valuable way of teasing out our own thoughts, exploring the problems that are inherent in immensely difficult issue, and that we should show our great thanks, especially to Elizabeth, who's spoken through a difficult cough, and to Lord Falconer. I hope both of them will be available in the reception that you can join us for immediately afterwards. Thank you.